I've worked with a lot of independent filmmakers who have gotten interest from a distributor, and of course that's very exciting to them. And then the distributor sends them a 30 or 40 page distribution agreement, and maybe even another document like a term sheet or something like that. And even though it's a very high quality problem to get that kind of document from a distributor, it's also can be kind of overwhelming and intimidating. The contract will refer to things typically like E&O insurance or a title report, CDSL, fair use letter, indemnification, chain of title, things of that nature. And a lot of indie filmmakers are not lawyers and may not have heard those terms before. And so that's one of the reasons why these agreements and term sheets will look kind of intimidating to them. In this video, I'm going to demystify a bunch of the common terms that you see in these distributor agreements and term sheets. And I'll explain what you need to do to fulfill the distributor's requirements regarding those issues. In the video description below, you'll see timestamps for each of the aspects of a distributor agreement that I'm talking about here, so you can skip to whichever one is most relevant to you, whichever one you want to understand. But before we get into that, so that I can keep providing this kind of educational content to enterprising filmmakers like yourself, please make sure to hit the like button and also hit subscribe so that you can see any videos that I'm putting out like this in the future. Now, without further ado, let's get into some common language in distributor agreements and demystifying that language for you. The first thing that we'll talk about is a title report. What is a title report? It's basically a report saying that the title of your film is not already in use. So either your distributor or your insurance broker, that is the broker who's helping you get E&O or errors and omissions insurance, a little bit more on that later, will almost certainly ask you for this. The company preparing the title report searches a bunch of different databases, the U.S. Copyright Office, the U.S. Patent and Trademark Office, the IMDb, the MPAA, or Motion Picture Association of America. Those are databases that are commonly searched by companies who do these title searches. And the purpose of that is to see whether any other creative work, whether it's a movie or a book or a song or what have you, is already using your title. The purpose of this is to avoid any legal disputes with someone who's already used the title of your film, so that someone who already used it can't claim that your use of it violates the Copyright Act or the Trademark Act or some other law. There are many companies who will do this kind of search for you. It's a simple Google search will help you find an affordable way to get this done. Now let's talk about a fair use letter. Again, this is another thing that either your distributor or your E&O insurance broker is going to ask you for. When you're using a video or an audio clip that's created by someone else or a photo that's created by someone else in your film, and you don't have a license to use that clip or that photo, you want to make sure that your use of that photo or that clip is protected by what's known as the fair use doctrine, which is a copyright law doctrine under U.S. law. This usually applies to documentaries, as you've seen in documentaries. When the filmmaker is interviewing someone, they often cut to news clips or they cut to photos and so on that give visual context to what the interviewee is saying. If the fair use doctrine doesn't apply to the clip or the photo that you used in your film, you'll technically be infringing a copyright or perhaps a trademark by using the clip or the photo, and you and the distributor could theoretically get sued for doing that. Your distributor doesn't want this because it creates a risk that it's going to have to pay damages to the copyright or the trademark holder, or worse, that the court that's dealing with the case could enter what's called an injunction or an order saying that the film can't be screened or it can only be screened in certain limited circumstances. And of course, that would be a disaster for you and the distributor. So your distributor or your insurance broker is going to want you to get an attorney to write a letter giving an opinion on whether each unlicensed clip or photo that appears in your film is authorized under the fair use doctrine. An insurer might require this in order to be willing to cover your film with errors and omissions insurance. Errors and omissions, by the way, is a type of policy that applies to, among other things, lawsuits claiming violations of intellectual property rights such as copyright or trademark. And again, we'll talk a little bit more about that in a little bit. What is fair use? It varies depending on whether we're talking about the copyright or the trademark context. If we're talking about copyright, there are 4 factors that a court would consider in deciding whether a particular use of copyrighted material is fair use, and I'm showing those on the screen right now. Briefly, it helps if you use the clip or the photo that we're talking about to give context for the content being shown in your film. For instance, if you were making a documentary about the history of surfing and you showed the copyrighted cover of a surfing magazine in an interview segment, you'd be using the magazine cover to visually give context for the interview you're presenting. That helps you in arguing that an unlicensed clip or photo is fair use. It also helps to use only a short clip of the copyrighted material. So in other words, if you show an unlicensed clip from a news broadcast, it's better to show only a few seconds of it rather than showing a few minutes. In the trademark context, if you show a trademarked logo or a phrase in your film, it's actually pretty unlikely that you're going to end up infringing that trademark. To infringe somebody's trademark, you would have to present it in such a way that the average person would be confused about whether you, the filmmaker, have some sort of association with the trademarked brand. And that's pretty unlikely in the context of a film, whether we're talking about a narrative film or a documentary film. For example, if someone in your film happens to be walking around wearing an Adidas t-shirt, the average person isn't going to think that you, the filmmaker, must work for Adidas or that Adidas specifically endorsed your film or something like that. That's just a common t-shirt that you see on people from time to time. So the issue of trademark infringement is actually much less likely to come up in the context of a film than copyright infringement is. By the way, the fair use letter is not something that you personally should be preparing. That, again, is something that a lawyer should prepare. Then they give it to you, and then you pass it along to the distributor or the errors and omissions insurance broker or whichever person asked for it. Now let's talk about E&O insurance. Let's talk about the details of that. I've mentioned E&O insurance a couple times in this video, so I might as well get into what it is and how you go about getting it. The main reason your distributor wants you to have an E&O insurance policy is to protect the distributor against intellectual property lawsuits and defamation lawsuits. By an intellectual property lawsuit, I mean a lawsuit claiming that the filmmaker used copyrighted material or trademarked material without permission. For example, the unauthorized use of a clip from a news show like ABC or CBS News or something of that nature without getting the permission of ABC or CBS to use that footage. By a defamation lawsuit, I mean a lawsuit claiming that your film made a false statement about somebody that was harmful to them. A recent example of this was the lawsuit that was filed by the actress Olivia de Havilland regarding the FX narrative show Feud, Betty and Joan, where she was played by Catherine Zeta-Jones. Olivia de Havilland claimed that the show defamed her because in the show, her character refers to her sister as a quote-unquote bitch, whereas in fact what she said was that she was a dragon lady. Olivia de Havilland ultimately lost that case on the ground that the statement that was made in the show wasn't defamatory. But this is a good illustration of the type of defamation litigation that can happen. To get an E&O insurance policy, you're going to have to talk to an insurance broker who will probably have you fill out a standard insurance application that tends to be the same regardless of the broker that you're using. Among the things the application will probably ask you for are a title report, which I talked about earlier in this video, and a fair use letter, at least if we're talking about a documentary that uses some unlicensed video clips or photos, which I also talked about earlier. So note that in your insurance application, you're going to need to be specific about the length and the amount of coverage that you're asking for. In other words, for how long is the E&O insurance policy going to cover your film? And how much is it going to be able to pay out in the event that there's some sort of problem, some sort of litigation of the type that we were talking about? Usually your distributor will tell you the details of the coverage that you're supposed to get in the distribution agreement itself. For example, the distribution agreement might say something like, you will obtain an errors and omissions insurance policy with limits of not less than $1 million/$3 million, which shall continue for the term of this agreement. What is the term of this agreement? That's the period of time for which the distributor will have the right to distribute your film. What are limits of $1 million/$3 million? That means the insurer is going to pay a maximum of $1 million per what's called an occurrence and $3 million in total per year. An occurrence means an instance when you're required to pay somebody who's brought a claim against you that's covered by the policy. For example, let's say you've got a policy with a $1 million per occurrence limit, and somebody sues you for infringing their copyright. And the case goes to trial, and let's say the jury finds you liable for $2 million. In that case, the insurer would only pay $1 million of the damages award against you, and you'd be on the hook for the remaining $1 million. I know this is a really horrible sounding example, but you can rest assured that it's probably very unlikely that this will happen in the context of an indie film. But I'm just trying to illustrate how an E&O insurance policy works, not trying to scare you. Anyway, $3 million per year. What does that limitation mean? That means that no matter how many damages awards or settlements you pay during a particular year in litigation regarding your film, the insurer is only going to pay out up to $3 million to you in that year. So if let's say you got sued 5 times for copyright infringement during a particular year. Again, this is just, this is just a hypothetical example. I'm not saying this is likely to happen. Let's say that you settled each of those 5 cases for $1 million. In that case, your insurer would still only pay up to $3 million to you in total, because again, the yearly limit on the insurance coverage is $3 million. And you would be on the hook for the remaining $2 million that you were ordered to pay or that you settled for. The distributor is almost certainly also going to want you to name them as an additional insured on the policy, so that the policy will also cover litigation or also cover claims against the distributor. If it's not obvious from your insurance application how to ask for this, just ask your insurance broker and they'll be able to help you through it. Once you've filled out the insurance application, the broker will tell you that they need further information if they have other questions. Or if they don't, they'll come back to you with a quote, which is the premium that you're going to have to pay to get the kind of coverage that you've asked for. Now let's talk about indemnification. One provision you'll almost certainly see in a draft distribution agreement deals with what's called indemnification. Probably the language will say something like, licensor, that's you're licensing the distributor the right to distribute the film. Licensor agrees to indemnify and hold harmless distributor against any and all claims arising from or related to any breach of this agreement by licensor. That means that if somebody else sues the distributor and the lawsuit was filed because of your breach of the agreement, you'll have to pay any damages that are awarded against the distributor or any settlement of the litigation that the distributor might enter into, in addition to possibly their attorney's fees. And this will all depend on really the individual language of the indemnification provision that we're talking about. What does it mean for the lawsuit to, quote unquote, arise out of your breach of the agreement? Let's say that you pledge in the agreement that you have a license to use all copyrighted materials that appear in the film. But unfortunately, you overlooked one clip that you didn't have a license for, and whoever holds the copyright sues the distributor for using the clip in their film without a license. That would be a breach of your representation in the agreement that you had a license to use all of the copyrighted material. Now, if the case goes to trial and the court awards damages against the distributor, and you signed a clause in the contract saying that you'll indemnify the distributor for any lawsuits arising out of your breach of the agreement, you're going to be on the hook for the damages award that's made against the distributor. Is this sort of provision negotiable? Usually distributors are unlikely to be willing to take this kind of provision out of their agreement because they tend to be very concerned about liability and ensuring in every possible way that they cover their legal bases. But one thing that you can do is to ask for an indemnification provision that protects you. That is, you could say to the distributor, well, if I have to indemnify you for any litigation that may result from my breach of the agreement, then you should have to indemnify me for any litigation that happens because of your breach of the agreement. That's only fair. In my experience, distributors are at least likely to go for this kind of modification to their draft. Let's next talk about a chain of title affidavit. What is a chain of title affidavit? Let's first explain what chain of title is for the purposes of a film. In legal jargon, chain of title basically means the documents that establish who has the right to use the intellectual property and any other proprietary rights that are associated with the film. For instance, the copyright in the screenplay of the film, which is one of the most important intellectual property rights associated with the film, is usually held by the screenwriter. For the production company to get the right to make the film, the screenwriter either needs to sell the screenplay outright to the production company, or the screenwriter needs to grant the company a license to use the screenplay for the purpose of making the film. The documents that reflect that the screenwriter either sold or licensed the right to use the screenplay to the production company are part of the so-called chain of title. For instance, a screenplay assignment agreement or an option agreement would be something of this nature. But the chain of title also goes beyond intellectual property rights. In many U.S. states, people have the right to keep filmmakers from using their image and likeness without permission. And this is something I've also talked about on this channel. This is why in a contract that a production company signs with an actor, the actor will agree to give the production company the right to use their image and likeness in perpetuity throughout the universe in any and all media and so forth. So the documents that make up the chain of title will include contracts that sell or license rights like copyrights and image and likeness rights. The reason the distributor needs to know which documents make up the chain of title is because the distributor needs to make sure that you, the production company, have the right to grant the distributor the ability to distribute the film. If, for example, you didn't get the screenwriter's agreement to use their screenplay in the film, you can't assign to the distributor the right to distribute the film. That right still belongs, at least partially, to the copyright holder, that is, to the screenwriter. That means that if the film gets distributed, the screenwriter could potentially sue both you and the distributor for violating their copyright, which would obviously create a big problem for you and for the distributor. What is a chain of title affidavit specifically? That's usually prepared by an attorney. The attorney usually lists a series of documents and confirms under oath that those are all the documents that make up the chain of title associated with the film. These would include, for instance, any contract between the production company and the writer giving the filmmaker a license to use the screenplay, contracts with people who appeared in the film that say that the filmmaker has the right to use their image and likeness, and so on. Next, let's talk about a cue sheet. A cue sheet is usually used to refer to a list of music cues or individual pieces of music in a film. Now, on that list, you'll usually see the time code in the movie where each cue or each piece of music begins and ends, the title of the piece, the composer, the publisher, which performing rights organization such as ASCAP or BMI has the right to collect the royalties associated with the piece, and perhaps other information for each cue. Here I'm showing an example of a cue sheet so you can see what one looks like. Sometimes the term cue sheet is also used to refer to a list of photos, video, and audio clips that are used in the film, usually in the context of a documentary. Like the music cue sheet, this list of clips and photos will show the time code where each clip starts and ends, what the clip contains, where the filmmaker got the clip, and whether the filmmaker has a license to use the clip. It might also show whether the filmmaker is claiming that the fair use doctrine, which we talked about before, allows them to use the clip or the photo. Finally, we'll talk about what's called a CDSL, which stands for a combined dialogue and spotting list. The CDSL is typically a list of all lines of dialogue in the film and the time code at which each line of dialogue is spoken. If the distributor wants to put dubbing or subtitling or closed captioning in the film, then the distributor will use the CDSL document that you give them as a guide to where to put the subtitles and the closed captions and so forth. Also, an attorney or someone else who's working for clearance on a film, that is making sure that the film doesn't violate anyone's intellectual property or proprietary rights, they can review the CDSL to make sure that no copyrighted or defamatory language appears in the film. So those are some of the more legalistic or scary-looking items that might appear in the draft distribution agreement or the draft term sheet that your distributor gives to you. Hopefully this has been helpful in answering any questions that you might have about this kind of intimidating language. If you have any other questions about distribution agreements and the kind of language that they use, please put them in the comments section. As usual, what I've told you is not legal advice. Of course, if I were going to give you legal advice, I would need to understand your specific circumstances and your specific needs. And right now, to you, I'm just a lawyer talking on YouTube.